Good morning, friends. Uh, Sorry for the delay. Of course, you all came at 10 o'clock and now at 10:30. Now, I'm very happy that all of you are here. I'm extremely happy about it. Now, the thing is that today the topic what we are talking about is the labor reforms and the labor code. You see, both the topics are highly voluminous. In fact, the time what is allowed now is not sufficient at all. So I have to try my level best to compress it as much as possible, but I will give you a main salient features of the entire thing. Particularly for HR people, particularly for HR people, I personally feel that one must be thorough with the labor reforms, thorough with that, because that's the basic foundation of industrial jurisprudence. That's how we should really understand conceptually how the whole thing developed through labor reforms today, what we are talking about, various laws, etc., etc., etc. So if you have to get a competency on labor management, if you have to get competency on I feel that you have to be thorough with the labor reforms. So that's exactly what I attempted to do. So that will be easy thing that one will study the labor and understand the labor laws. Then your understanding codes will never be a difficult one. That's exactly that. Now, before I really start, let me give you some small introduction. You see, the word labor reforms is a very familiar word to all of us. Not now, for the last 30 years. It's a very familiar word. You know, in all the budget speeches by central finance minister, when they present the budget, he or she will make a statement. The government has decided that we'll take initiative for labor reforms. Then all of us get enthused. Okay, let me do this. Go. Yeah, CII, FE, everybody will say, welcome, 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 welcome. Then after 1 week, the trade union says, we'll go on strike. We'll go on a mass strike. We are against this labor reforms. Then what happens? The whole thing kept in dark. Finished. That's exactly what has happened. In my experience, what I've seen is this, the budget speak makes, these people threaten for a strike, and the matter is over, and matter is forgotten. That's exactly what's happening. So, the labor reforms is such a very sensitive topic. Everyone looks for, the government looks for a purpose, right? And then the business looks for some results. The trade union, the workers, they look for something else. So the combination of everything is a little complicated. But now I tell you, labor reforms in India, it's not today's. It is as back as 1931. When British India was here, the period goes back to that. The intention was that probably all of you are aware, pre-independence. How was the Indian situation? All of you know about it. Because on account of First World War in 1920-21, lot of drastic effects have happened. Rising cost of living, unemployment in the country, and then the people were not able to eat themselves. And of course, the British were there, they got their own style of management. And they got their own this one. And they used to hire people, not directly, because they don't know whom to recruit. They used to give some agencies to hire. So the agent used to supply them ex-labor, point of labor. We don't know what salary he's going to give. And what are the timings? Nobody knows. There was no control at all. There was no control. Under the wages, there was no control. They were paid very poor wages. Total exploitation of labor was taking place. For all these things happens. Now what happened? The welfare and health was a big major issue at that time. Accidents, no compensation. Children, they were employed in the workplaces. No restriction. Women, they were exploited. All these things were happening at a very rapid rate. Now, at that time, 1910 or 20, One prominent trade union leader, I think his name is Dr. P.K. Shinde, or Shin or something, I forgot about it. He took a lot of initiative. He took a lot of initiative. He said that he totally said that this must be put an end to this because total resistance started. Then what happened? The British government thought, okay, let us think of assessing the situation. Let us try to understand what is the situation. Then let us try to reform certain things. This is the background of the labor reforms. I'll just quickly take you through one by one. So as I said, all the labor reforms, the government looks for some point of view. They said, we want national economic growth, employment opportunities, and then good fair wages for everybody, good tax return, everything government looks for, nothing wrong in it. Now here the employer, we look for foreign direct investments. We want to invite, and the return on investments. We can't lose this investment on account of this. At the same time, we create employment. Want to pay good salaries for the people. We want to encourage this. So this is exactly what the industry looks for. And here, the trade union, as I said already, they look for one thing. We want to protect our rights. We want to protect our welfare. We want to see that our workers get better wages, best wages, and good living conditions. We fight for it. So this is how the everybody looks for. What happens, all these activities must be balanced. But the crux of the issue. Because you can't be one-sided. If you're one-sided, the triangle goes like this. If the triangle wants to be stable, it has to be highly balanced. So this is the trick of labor reform. Now let us go through how the whole thing happened. Quickly click through because the time is also enough. Okay, I told you already. As back as 1929, the formed, and 1931 the report came. And let us also look at, in the meantime, the government also took a lot of initiative. After independence, they formed various committees, establishments, so many things they did. That also added to a lot of things. I'll just quickly take you through that also, if possible. We have got 3 Labour Commission reports. In 1931, 1969, and 2002. We got 3. You see, the thing is that India, right from beginning, they want to become a developed nation in the world. That is the ambition and objective they have. They want to make India as a model in terms of everything. So, from that point of view, of course, whatever effort they have put in, let us see. But the objective is very clear. They are keen on that. They are not like any other country, okay, let's not worry about it. They are very keen. They said, we must do this, let us do this, let us do this. This kind of a thing. Now, 3 Labour Commission report has come. Now, ladies and gentlemen, I don't know how many of you have gone through these reports. I'm not very sure. But if you put all 3 reports, it contains around 3,500 pages. 3,500 pages. Now, as a first time, I thought that let me do something. So I read the whole thing, all the reports, and make it as short as possible. With 200 pages in the book, I have put it. I have compressed important issue, important points, I have put it. Now, today in presentation, I have to further compress to only 30 or 40 slides. Look at this. Anyway, I will do my best. Okay, this I will take through. Now here, let us look at the reference by British government. Yeah, it will be very important. To inquire into and report the existing condition of labor in industrial undertaking and plantation in British India on health, efficiency, standard of living of the workers, and on relation between employers and employed, and to make a recommendation. Look at this reference. Reference is a very focused one because they know the existing problem what they have. The situation in India, he said, let us focus on that. So this is the thing what they have done. So the commission, first of all, they appointed in 1929, and then October 30 they started. They traveled around 16,000 miles throughout the country, visited 180 establishments, 490 memorandum, 830 witnesses, and submitted a report to the Parliament in England. What are the things they did? The migratory and factory workers, what is the situation of migratory and factory workers? It's a beautiful study made by them. Because what happened, some factories were there, everything was there, but people are all migrated from village to urban, village to urban. When a person migrates, what are the types of problems we face it? Any number, plenty of issues, plenty of problems. Housing will not be there. I don't know what to do. Or health is. So all these issues was a major, major issue. Then hours of work, I told you already. No specific conditions of work were horrible. This is the kind of thing. Then condition of plantation was worst. Then wages, no control at all. He gets it, or he doesn't get it. This is the kind of thing. Then unregulated factories. You see, today, of course, today we have got Factories Act. There is a regulated. If you're more than 10, you have to take license. If you're more than 20, you have to take license. When you take a license, you are regulated. At that time, no regulation at all. Without license, the factories are running, unregulated. 40, 50, okay, enjoy it. No regulations. So this is a major issue. And trade union and dispute. Here, the peculiar thing is at that time, trade union was coupled with our freedom movement. The freedom struggle was going on at that time, the trade unions coupled it. So there was an added problem and everything connected with this. Then housing and accident compensation was a big mess. And income and indebtedness of industrial workers. So these are the topics that completely deliberated and then came out with a specific recommendation. I told you already. Now, on account of this outcome, look at this. On account of this outcome, 13 legislations were enacted to address all the concerns raised by the Labour Commission, Royal Commission. 13 acts were enacted. All these things, Payment of Wages Act, Minimum Wages Act, Factories Act, ID Act, Plantation, Mines Act, ESI, PF, Working Conditions, Journalists, all these acts, it came out of this. Look at this. At least now what happened, some kind of a discipline has been brought, and then, in fact, employers welcome this. Because today I'm running an industry with no regulations. But today I'm running an industry with regulations means, okay, it's a good thing for me. So industry also welcomed this kind of a move. This is exactly what happened. So aiming at the working population, I told you in this short, study was conducted on all these things. Study related to working conditions they did. Recommendation into the legal system by way of suitable legislation, I told you already. And then studies and recommendation highly elaborate. All these things were employment of women based on several recommendations also have been made. So this is a wonderful thing made. This is from the point of view of working population. Now let us see from the population of industries, how the industries looked at this recommendation. 30 new legislations were introduced as per the list above. Yeah, it's a positive thing for the employers also. While Commission appreciated the business growth, but no adequate support towards accomplishment of business growth. That was not given. Maybe for a different reason, because what happened at that time, just industry is looking at, so we can't expect too much of support for them, but that was not much. See, the objective commission to study and evaluate condition, its recommendation, it was only beneficial to the employee as well as employer. And there is no, of course, legal support to employers in terms of productivity, rationalization, even automation. There was support. Okay, that we need not worry about a small thing. Even today, so we are having this. The entire report, one can see no support indicated to employers, but the support was given by way of legislations. In short, this is the, what you call, the scenario of first Labour Commission, Royal Commission. Now, let's come to the next one. Now, in 1947, we got the independence. The moment we got the independence, the government of India committed to carry on and improve the entire thing, like industrialization, employment, all these things they wanted to do it. In 1950-51, what they did? They introduced 5-year plans. 5-year plan, all of you are very familiar. On account of 5-year plan, it aimed at a lot of growth and expansion, etc., etc. And this one, the intention of the government, one of the intention was that they wanted to generate huge employment. That is the reason why if plans were introduced, and then the government thought we'll form public sector industries. What they did was that they made a lot of public sector industry through this plan. The public sector industry is mainly to focus, only emphasis on to give as much employment as possible because the private sector cannot give. Private sector cannot give employment because of so many things. So then what happened? This how the whole thing developed a little bit. No financial support to private sector to survey on their own. This is a major drawback for the industries till 1969. The broad scenario. No finance. They said that if you want money, you go and borrow. That's it. We can't give any support. So this is the situation for the private sector. This is a major drawback in the private sector. Then another major thing is that this Industrial Development Regulation Act, they impose heavy restrictions on private to expand, even to increase their manufacturing capacities. This has put a lot of restrictions under this act. If you want to expand your factory, you can't. Unless you go and go approach the government and request them, blah, 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 everything, we will not give it. If you want to add one more product, what you are manufacturing, you are not free. You have to go to government, seek their approval and all that. Who will give? It is not that easy to give. Suppose you want to make a component, we have to prove that this component is market worthy and I am going to sell it, it is going to be a profitable thing. Otherwise, no, please, no, it's not possible. Because I've seen with my own eyes the industries, what they were fighting at that time. In fact, I was in one company where MD went to abroad and then he wanted to bring some kind of a, not even machinery, simple technology, that's it. To that, we applied for permission. We almost took 1.5 years to get the approval. By the time, the technology is outdated. So this is the problem the private sector face under this scenario. And that's why I told you, any proposal, full capacity utilization, location, everything they had. In addition, the increased industrial unrest due to. Because what happened is, if you take the industrial unrest, because workers were demanding, definitely nothing wrong with them. They want better condition, they want higher salary, and they were doing it. But the employers, they got limited capacity. They don't have capacity because you have to fight only with internal competition. Internal competition with public sector undertakings. So there is no capacity. So you can't pay. Then what happened? This led to a lot of industrialists. We went on and a lot of strikes, lockouts, whatnot, everything went on. In addition, 1969, one more act they brought into force. This is called MRTP Act. This is one more other tough. They said your foreign equity you can't take. Foreign equity, you have to prove. Why do you want this foreign equity? And that too, not for all the products. They selected few important products. And they said, for this we'll give you some kind of a equity. So even also foreign equity was not possible. So what happened? Foreign firms were not allowed to invest more than 40% of their equity. Who is interested? Private sector. So this is another major blow to industries. In certain industries, 51% foreign capital, but you are subjected to a lot of restrictions in terms of obtaining licenses, clearances, etc. During this period also, we saw unrest was high, very high. We saw a lot of strikes, violences, whatnot, everything we saw at this point of time. This is scenario after independence up to 1969. Then again, as I told you already, post-independence. Now thereafter, the government thought, okay, now everybody is facing this problem, private sector is facing this problem, there are a huge industrial unrest, this is going on. Now why not we form one more reform commission and then we'll give a reference to that. Then accordingly, in 1969, second commission, first labor commission headed by Dr. Gajendra Gadkar was formed. Now this was the beginning, first one. Now look at the references. It's very interesting. See, look at one. To review the changes in condition of labor since independence and report existing condition of labor. So they say that review previous condition, review the present condition and give a report. That's it. Nothing else. And secondly, to review the existing legislation and the provisions intended to protect the interests of labor, to assess their working and advise how far these provisions are served to implement the directive principles, state policy, and national objectives is this one. See, if you see this reference, nowhere the industry is seen here. They say, look after this and give you a report. You study this and give us a report. So this is exactly what they did on that. Now here, all topics they discussed. If you see the report, it's a very, very elaborate discussion. Now, why don't you, gentlemen, why don't you go? As a matter of interest, you must read this. You must see this because I told you already, this is a basic foundation of your international jurisprudence. Because here, though I have only made a point, each topic has been deliberated by the Commission in very much detail with lot of data, statistics, and logic. Because the stakeholders are unions represented, management represented, the government people they represented, NGOs represented. So all these things are put here in this report. So this is worth reading. I think you must read this. Of course, the shortage of time, I am not able to go further, but it's a must. You must read this because I told you already it's very important. So again, I told you it's only discussion and recommendatory. This report was discussion recommendatory. And integrated social security, they also recommended at that time. They said that social security scheme, what we have, so like ESA, PF, etc., why not we combine it? Like what we are thinking now, they thought at that time itself, why not we combine it? So this kind of thing. Then also they took up the recognition of trade union. This also point was brought up. And tripartite reservation systems. This will encourage tripartite reservation systems. And here also they mention common labor code. See, look at this. So this is the first initiation by one of the commission on common labor code. They gave a lot of reasons for it. Then Industrial Relations Commission, they said that, okay, let's not go to tribunal, let's not have this. We will have industrial relations commissions. Instead of tribunals, we'll have commissions, we'll do it. That was the recommendation made at that time. Then joint management councils, they said. And then, although the definition of industry, workman, wages strike were discussed, but nothing happened. They said, no, we will not touch it. Existing, let it be here. We will not touch it. Because they went to the, probably, the definition of industry probably were very familiar. The three phases of interpretation went to definition of industry. In early 1970s, one phase, the definition of industry means it was interpreted that hospitals are excluded, education institutions are excluded, charitable institution, factory means industry only. It was a limited affair. But thereafter, again, second phase came, it was expanded. They said, no. Hospital must be included as an industry because people work there. Education institution, people work there. Maybe teaching staff or non-teaching staff, they work. I think we should do this. So again, it was on account of a BW versus Rajapa's case. They gave a beautiful judgment, wonderful judgment, expanding everything. So they said, okay, we will not touch it. So they didn't do anything on that. Now, what are the aims at working population? Changes and conditions independent, only report, that's all. They gave a report. Okay, this is kind of thing. Advise how far the previous implementation, state policy, constitution, labor matters, and objectives, social society, achieving planned economic development. This is also just advisory. This is not a specific point for please do it, please do it. No, it is not that. It is just advisory. This is exactly what they did. Then also they emphasize education, training, skill development. This also they said employers must think of this. Employers must think of this, all this. They put the responsibility on the companies. You do this. This is kind of thing. They reduce unemployment, then protect collective individual rights guaranteed in the Constitution, ensure fairness and equity with working population. So in the legal support to industries, most of the recommendations are addressed to employers. There is no support. It's only advice. You do this, you take care of this, So nothing much happened in this case. Appreciate the business growth. They appreciate, the commission appreciate, oh yeah, business growth is fantastic. It is very good. That's right. But thereafter, they kept quiet, no support. In what way we can support the industry? Either a finance or by something, something, something. Nothing came through. This is another major problem. When here, number of strikes and lockouts were a common phenomenon at that time. No stringent measure even think of to remedial measures. Nothing. They even saw number of strikes, but nothing happened. No incentives for foreign direct and promote industrial goals recommended. They also did not recommend anything, foreign direct investment. So this kind of thing. No legal support to industry and challenge to automation and rationalization, no support. See here in this report, we can see the report, it is not supporting the industry in any manner. It is just ready made and they advise you, you do this, you do this, you do this. But don't ask me any support. You do this, that's all. So this is the kind of recommendation they gave in this one. Now let us take the scenario between 1970 to 2002. How is the scenario? Now here, as I told you already, monopoly is here. Trade practice is already there. And then what happened? Era of rebellion started in 1980. Here what they did, they gave very slight leverage, a slight leverage of what they call the capacity indicated in license could be re-endorsed provided it was 25 more than the license capacity. Then automatic re-endorsement license capacities in 1988. Then broad banding and selective delicensing extended only 25 set of industries. But here also, employees had no liberty to do on own. They had no liberty. They had to approach Government of India. They had to approach the bureaucracy. They have to seek their approval. If you have to seek their approval, you have to provide lot of data, approve, witnesses, whatnots. So here, the bureaucracy played a big hell and a big game. The bureaucracy. So industry also here face major triangular cases in this case. One side, you have labor unrest. Another side, you can't expand your own capacity. If you want to expand your capacity, you have to go to the Government of India, elaborate process, time, or whatnot it takes. And this is a scenario at that time. Then, in addition, the ID Act was amended in 1976. Layoff, retirement closure, make a major hit. And of course, Section 9A, service conditions that remain to be continued with all these things. So, no touching, nothing was done. So, actually, industry faced a lot of issues and problems. So, in 1969 to 89, the industry faced innumerable number of strikes and lockouts with violences. In fact, I was there I've seen this scenario in late 1960s, 1970s, 1980s, 1990s, I have personally seen. In this period, the number of strikes and lockouts and violence was terrible. Not even one industry is free of anything in at least two or 3 days. It's not possible. Every day, there's a major issues we faced at the time. Then here, same thing. Then what happened? You have Bangalore publicity strike, HAL, HMT, BEL. They went on strike for more than so many months. And in Bombay, what happened? Textile industry headed by Datta Samant, probably you may be aware. The strike went on for 3 years. 3 years. And ultimately what happened? Everything finished. All textile unit in Bombay finished and people went like, it was not the word, they were totally, they were living on all unwanted occupations they do and this is suffering they did. So this is the effect of the entire thing, what the industry and people saw during this period. Then here in the meantime, some interesting developments. Some Government of India, what they did, they formed this National Labour Law Association in 1980. They drafted an Indian Labour Code. They drafted one because somebody said, well, let's do it. Actually, this commission consisted of eminent people like the judges, highly qualified advocates, trade union leaders, whatnots. They deliberated. They said, we'll do it. But of course, all again, cold storage. And task force for employment opportunity chaired by Dr. Monica Ahluwalia. This also they formed. Then major amendments of Trade Union Act, this is another dangerous thing what they did. 1988, I don't know how far you remember, there are major changes proposed in the ID Act and Trade Union Act. Major change. But of course, there was a lot of reactions and oppositions were there. Then Government of India, what happened? They referred the bill to one Ramanujan committee in 1990. Ramanujan committee. So Ramanujan committee sat for almost for 2 years and then they gave their own bill. But ultimately, nothing happened. So this is a kind of scenario, friend. And Sanatana Mehta committee on child welfare. The task force on social security. Look at here. Here also, unification of ESA, PF and pension schemes. So that committee recommended. I said, we want to combine it, make it a combined. There's a kind of reaction they give. And Booth-Lingam Committee on National Wage Policy. Booth-Lingam Committee. They also formed. They went to all these committee reports, I tell you, it's really wonderful, I can tell you. Please go through this because it will enhance your knowledge like anything. Because a lot of data has been put, a lot of logic has been put. So you should be able to understand and then, your mind will be very clear about this is the kind of logic they have put. You should appreciate the logic. Outcome is different thing, logic. Then National Commission on Rural Child Welfare, Dr. Harman Roy in 1991. A National Commission on Self-Employed Women and Women in Informal Sector by Mrs. Elia Bhatt in 1988. Because in all the commission report, this was a major issue. Look after the women and women employment and this one was a major issue. So this commission was formed. They also gave a lot of recommendations. Then afterwards, gentlemen, we have come to the liberalization era in 1981. Now this total scenario is going to be changed. It changed. In fact, when this reforms came, actually nobody anticipated, I can tell you, this come just like an ordinance. One fine day, I think P. N. Narasimha Rao was the Prime Minister, on one fine day, he just made a press statement and removed the entire thing. So it came a big shock to everybody because your product is thrown globally open. That is the kind of thing. So, abolition of industrial licensing. They said you don't have to worry about it. If you have capacity, you manufacture whatever you want. They're totally removed. And then simplification of procedures. Then reduction in public sector reserve for that's also eliminated. Then disinvestment selected public sector undertakings. Foreign investors were allowed to invest in Indian firms. Today, that's why now we are seeing all MNCs just flooding in, coming in. Why? Because of this policy. Then liberalization and trade, rationalization, massive reduction in trade structure, and all these things came in 1991. I guess sudden it came. Now here what happens? The industry have to survive. If they have to survive, they have to bring new technology. They have to rationalization, automation, increase in capacity, not only increase in productivity, reduce the cost of production as much as possible to meet the global competitiveness. Otherwise, who is going to take your product? So this became a major challenge to industries. Now here, what happened? We had a bottleneck. Section 9A. You can't change it. If you want to modernize anything, you have to go and beg with the union and take their approval. Otherwise, you have to go to government. If you go to government, it's a matter of dispute. Go for years together, nothing happens. So this became major bottleneck for the industries and all these things. So this is a major hurdle. And there was no legal support to industries in this company. There was no legal support at all. Yes, we have done it. If you want, you survive on your own. That's it. So this kind of a peculiar thing, this happened. Then, for first 3 years, in fact, I was there at that time. First 3 years, we took 3 years to educate the union and the workmen about the effect of globalization. We had to educate them. We had a number of sessions, classes. We told them, Baba, this is the effect of globalization. So you have to involve yourself. You come with us. You help, then we will help you. We'll take care of this. Similarly, we convinced the trade union leaders, and ultimately they understood. So this took almost 3 years, gentlemen. 3 years, I can tell you. I'm not exaggerating. I've seen it. 3 years we took to just to educate them and bring them to one line of thinking. Then what happened? On account of this, we shifted to collaborative approach rather than confrontation. Because everybody learned that in this situation, I can't fight with people. I want help, I want cooperation, let me collaborate. Okay, you give me something, I will give you something. So this kind of a culture started. It's exactly what the employers did, that's all, nothing much. And of course, we should compliment the trade unions because they also appreciate the view and they extended full support and they became a what do you call, part and parcel of the entire exercise. So here what happened, the industry scenario changed from collaborative from confrontation. This is a major issue. Here, look at here also. There is no government support in this matter. It's all initiative by the industry, by the management, by the workers, by the trade unions and everybody. Nothing else. So this approach, then what happened? The number of strikes and lockouts drastically reduced. Drastically reduced, I can tell you, because everything you have to discuss. In fact, when we wanted to modernize our factory in Pinya, when we involved them, it became very easy thing. Of course, we had to educate them, but it was easy. Similarly, in all the problem, you also undergone the same. You would have got the same experience on this. So this is the benefit of the entire thing. Now, after this, because what happened? We were pressing the government that no, you remove this restriction, you remove this, you remove this restriction, this kind of thing. I can tell you one small incident. I was the chairman, I was the secretary of NIPM Karnataka branch in 83, 84. At that time, all these petitions where we were filing it to government, please relax 9A, please relax this, please relax that, and all that we were making. Then PM Sangma was the labor minister. He had come to Bangalore. So we invited him for a talk and then we made a big representation to him. Sir, we want this, we want this, we want this. You know how lightly he took it, I'll just tell you. He said, okay, friends, all of you are here. I'm very happy. I've seen your presentation. You want change in section 9A? We all said, yes, sir. Okay, granted. And he said, you want to remove chapter 5A, 5D Act? Yes, sir, we said. Okay, that is done. And he went up, that's all. What happened? So this is the kind of thing what happened. But anyway, now here in this commission, now please read the reference. This is very important. 2002, latest second commission. Rationalization of existing laws relating to labor in the organized sector. Look at the reference. And secondly, suggest an umbrella legislation for ensuring minimum level protection to workers in the unorganized sector. Okay, that's fine. Look at the first reference. You review, as far as the organized workers are concerned, review the laws and give the recommendation. So this is the point of reference by the Government of India to this commission. And thereafter, here, there also they identified certain factors. The globalization of industry, liberation, trade and industry. Okay, give me a report. And then rapid changes in technology and the consequences and ramifications, give a report. And the effect of these changes are likely to have on nature and structure of industry, on methods and place of production, on employment and skills necessary to retain employability, etc., etc. Look at the point of reference. And the responses that are necessary to acquire, retain economic efficiency and international competitiveness. So, gentlemen, here also, if you can see this point of reference, don't you think that is just one-sided? You are fighting, nobody looked into this. So, this is the kind of the report in second commission. Here, on key observation, you can see, I told you already. Now here, to start with, working permission but not the industry. That's a point of reference. They said, okay, we look up to this one, but we're not here. This is very clear on this issue. The terms of reference they give is all theoretical approach. Industrial development progress, impact of globalization, they were not only India, For various countries, they made a big study and gave a big report. I mean, I don't know what it, so that's a different thing. Approach to review laws. They wanted to consider all these our issues, like our National 9A and this and that thing, everything. They reviewed, ultimately they said, okay, no change is required. Not necessary. Let's not worry about it. So just left it at that. Then review of laws, unorganized sector, they had an excellent study. They made a wonderful study of unorganized sector, how the unorganized sector should be protected in all respects. They made a fantastic report on the, it's worth reading it because you will get a lot of ideas. Then women and children, skill development. Skill development also they give a very good, what you call, suggestions they have given. This is very good. Fine, that's all. And of course, they have discussed workers' participation in management and then employment scenario, review of wages and wage policy, all these things. But ultimately, this is only a report recommendations. But again, I told you already, no specific support to the industry in any manner. So this is the kind of thing. And then here, at this strong point made by employers stand toward FDI completely positive effect cannot be accommodated. Here we argued. We argued strongly that if you had to get the benefit of globalization, impediments under labor laws must be removed, otherwise we can't do it. That is a strong point urged by the employers. You know what the committee said? Look at this. Response by the committee. This is exactly what I have taken from the report. It's not my words. These sentences I have taken from the report and put it here. They said that labor laws are not coming in the way. That is their findings. Depends very much on managerial skills and in manage integrity and honesty. It depends on that. You've got your set of managers. It depends on their efficiency, effectiveness, forecast, whatnot. You have to utilize your managerial skills to encounter all this problem. Labor also is not a problem at all. It is not coming in the way. This kind of logic they put. Then look at this. This also is taken from the report only directly. Creation made a conducive culture and it depends on individual worker and his attitude to work. So how do you build up attitude? You have to do it. You have to make him comfortable. That's your job. Condition of work that relate to work. Then management and attitude to workers. What is my attitude to workers? I have to change myself. So normal, so before itself and commitment and a sense of play, justice to constituencies. So clearly they said, forget about it. They said, here also, this is also taken from the report only. What they say, hire and fire is constitutionally valid. Because they say, no one can, what do you call, trespass into the individual rights. Workers have got a right to go on strike. The management has got a right to declare lockout. We can't trespass, so we can't trespass. So this is the kind of thing what they did. And they also put another thing. See, let's say for instance, you want to lay off people. You want to retrench people. What they say is that social acceptance is necessary. It means that the entire society must accept with you, yeah, I think layoff is required, retirement is required. You have to sell yourself to community and the union and the workers. That's your job. It's not anybody's job. So social acceptance. You have to take it. Then do it. So this is the justification made by them to say that no change in law is required for this. It's all new hands, do it. This is the kind of thing. But it's emphasized same thing. Here again I repeat, it depends on effectiveness of manager, not by changing laws. So today what we are seeing is, did not recommend any changes. The commission report, they did not change any report and this one. So finally it concluded that no changes in laws are warranted. This is the final conclusion of the entire report. Now, of course, they talked on other things like living wages, what we are talking today, and fixation of evidence-based facts, that's ILO and Supreme Court direction. Now, today we are seeing, the fact-based wages. There's so many calories, this, and so many things. So based on this, must be given. And also, they said national level floor minimum wages. This also they recommended. They recommended with, of course, justifications and whatnots. And they also emphasized the recognition of trade unions and negotiating agency councils and grievance redressal machinery. So here also Commission put a word. The agreed must be provided an opportunity to approach the cancellation of the, here itself they put it. So the same thing you are finding in the code also now. So they said that worker must be liberty to approach either arbitration or conciliation. He must be able to go. They have put it. And the contract labor, they also recommended distinguished core and non-activities. They cited the example of Maharashtra. They said, we have done it, so why not you people also do it? There's a recommendation made by the commissioner at the time as far as contract labor is concerned. Then, of course, what are the commission also drafted the bills. Today, what we are seeing in the courts is all bills drafted by the commission itself. It's annexed to the report. They drafted law on wages. What we see today, code on wages, the same thing is drafted by them. Model standing orders, this also they drafted. And small enterprises in Renaissance Act 2002, that is, this aimed at small industry like less than 20, how they should function, what they should manage. So they drafted an act separately for small industries. They did it. And law on labor management relations, this they did. Gentlemen, look at here. This is one thing. The commission strongly recommended the managerial people also must be given equal protection under the act. Against today, since they are not workmen, we do anything whatever we want. But commission said nothing doing. They also should have protection. So if you want to dismiss a manager, you have to follow all the principles. You can't do unfair dismissals. So in the bill, they include this also. Protection of managerial and other employees against unfair dismissal, denial of remuneration. Inside in this bill, they included this also. But of course, luckily, it's not affected the code. But what I'm telling you is that how the commission looked at the whole thing that we have to see this. So this kind of thing. Then of course, Industrial Relations Commission, they suggested National Healthcare Insurance, Occupational Health and Safety, and National Policy. So this is the outcome of the entire thing. So if you look at the working population, lot of plus points are there. They recommend need-based minimum wages. They recommended this. Wage limit, no limit for ESI and PF. They said everyone, no limit. Today we got nothing, remove the entire thing. Everybody should be covered irrespective of their salary. Grievance redressal, I told you already. Definition of workmen to include all employees, production to managerial people. This also they added. Beneficial. Workers to be taken into confidence of service conditions, social acceptance. So you have to take them into confidence. You do it. That's your job. So comfortable for the union and whatnots. Unemployment in insurance scheme, unorganized sector umbrella legislation. This is exactly what is it. Now on the community support to industries, it is ruled the reverse. No relief under Section 9, I told you already. Commission said, industry must be helped to protect its viability and competitiveness. But how? But how? No answers. No answers. So this is the outcome of the report. Grievance that the proposal leads to multiple increase. Definitely, if a worker has to raise a dispute, it will lead to multiple disputes. This is a big issue. Then onus on managerial effect, I told you already. Then need-based measures, but no obligation towards increasing productivity by worker. So they did not mention a word. A need-based living wages, it means that is cost to the company. At least how the productivity at least can be linked? No. So what happened? Heavy penalties on employers. The commission also recommended there must be deterrence on the employers. Violation should never be tolerated. Put them heavy penalties. That's what they recommended. So friends, this is how the report says. Now all these 4 labor codes, what we are seeing today, more completely based on these bills and some changes here, there and all that. So this is the base of our, labor codes. This is the base, this is the basement. This is how it is. Now here I just made a explain. all the three reports, all the three reforms, how it is balanced. Royal Commission is only my perception. They have balanced one, which means that it is not one-sided. It is highly balanced. I think we should say that 1931 report is highly balanced one between working population and industries. Now, when you see the first commission report, it is not highly balanced. It is in favor of workers, not in favor of industries. And third one, again here, it is not in favor. So this is the kind of thing what we are facing today. Now, okay. Now, any doubts and clarification on this? We can spend our 5-10 minutes to clarify on this labor reforms. Any doubts, any questions? I will just share with you. Let's discuss it before I go to quick go through on this. Any doubts? Clear? Is it okay for you? My presentation is okay for you? Or you got any inhibitions? Oh, this fellow is boring and all that is okay. Should talk. For everything has been a base. Even 1931 Commission also, it is based on the recommendation of minimum wages came, payment of wages came, factories act came, and all these things. Now, these changes also based on report because in the reports, what I see is that logically they have put everything. Logically, it is not that of course we may not agree. That's a different issue, but logically they have built up the case. It's a beautiful document to read and understand. So my suggestion is that, friends, first what you need to do is that, if it is possible, please go through this report. This is wonderful. Please go through. Second thing is, study the existing laws. Understand? Study the existing laws. Then what happens? You create the first platform is going through labor reforms. You give background. Then existing labor legislation as on today. That's one thing. Then what happens if you're thorough with that? Then understanding the labor codes will be very easy and convenient for you because your mind is already set. Everything is ready there. So understanding the labor code will never be a problem. Will never be a problem. So this is the kind of thing what's happening. Now that I'm going to tell you now, what are the negative points I'm going to tell you, what are the negative issues, negative points. I'll just briefly tell you.
This code on wages drafted in 2019.
Yes.
Now we are in 2022.
Yes.
Where it got stuck, sir?
I said to you, it's only bureaucracy. I tell you. In fact, the previous report, it came in 2002. The second Labour Commission, 2002. What did the government do till 2017 or 18? They slept. They slept over the issue. Nothing but slept over. And after they opened their eyes, oh, no, we'll open it, we'll do this, we'll do. Then the activity started. So what happens, of course, these codes, the bills drafted by the commission has been very useful for these people to redraft it. If you see the bills drafted by the commission, and if you see your code of wages bill or whatever it is, almost 80-90% similarity is there. Almost, yes, some changes are there, but more or less. So this is the kind of thing.
Thank you, sir.
Okay. Of course, this code number of definition, we even know that the number of definitions have been reduced from 377 to 204. Then existing provisions have been reduced to 465 from 1021 out of 29 labor legislations combination. 29 legislations have been, and this is the summarize this one. We'll present you all salient features which requires your attention because I will only present that. I will not go into details because it's a very vast subject. Code on wages. Let's talk this first. Now here it's a combination of 4 acts. We will be aware, so I don't have to repeat this. You are already aware of it. There's got 3 chapters: minimum wages, payment of wages act, and payment of bonus act. Each chapters. And of equal remuneration, there is a provision, a clause has been put in the bill itself about that. Now here, employee has been defined to include one and all in the categories in the establishment. So this is the first time. Because today, if you see the minimum wages act, the word it says workmen, minimum wages act. Here, the employee in payment of wages act says 21,000, 24,000, below he is covered, other provisions are not applicable. This kind of a thing is there. But here, the logic put by them was that because this is one of the security scheme, wages is security scheme, what you call remuneration scheme, So everybody must be included, even a manager. He also must be an employee. That's the logic they put. So they have put, that's why employee has been defined. Although worker has been defined in the ID Act, here in this code, it's only employee, employee, employee everywhere, except of course, we see a slight difference in Factories Act chapter and then in IR code, a slight difference. Otherwise, everywhere employee, employee have been mentioned. Next definition is the wages. This is a very, very critical thing, and this is a major challenge for every one of us. Of course, existing definition, you maybe know that existing defines so and so and so. Exclude does not but includes house rent allowance, present definition, but excludes value of house accommodation, PF contribution, traveling expenses, some paid to defer certain expenses, gratuity payable, they are excluded. Now look at this under this code. What they have said, basic plus DA plus retaining allowance, if any, and exclusions. So, any bonus payable, there is a big question. Value of any house accommodation, any contribution payable employed towards PF, any conveyance, sub-paid to defray certain expenses, HRA, and remuneration payable under any award is a dangerous thing. Any award given by in favor of worker or in favor of this one, this is also excluded in the category. OT allowance is another thing. Any commission payable, this is also excluded, and gratuity payable. So this is how the first portion of the definition. Second part, what they have said, if payments made by the employer under clause A to I exceeds one half, and that will be deemed as additional wages. So this is the kind of thing what they have done. So I just drafted some examples for you. You can have a look at it. Step number one, what we calculate. First step, is it basic plus DA and all is a gross salary. One packet you have to make first step. Second step, what you have to do? Take out all the allowances, that is A, B, C, D, E, F, G, H, I, up to I. Make a total. What is the amount it comes to? Then third step, what is the 50% of second step? Third step. And fourth step, what is the total basic salary and DA? Whether the 50% in third step exceeds the total of basic and DA. If it exceeds the portion to be considered as wages. This is the kind of thing. Now here I will give some examples. Let us take an example of one basic plus A 15,000. Let us say his other allowances that A to I is 40,000 rupees. Now one half of 40,000 is 20,000 rupees. His basic DA is 15,000. So 20,000 exceeds basic DA by 5,000 rupees. So that 5,000 rupees must be considered as wages. He's become 20,000 as treated as wages. So this is for the purpose of your provident, gratuity, whatnot, everything. Now this is a very peculiar definition, very complicated. I don't know why this made it. Let's say another example. One person basic DA is 25,000. Other range is 45,000 rupees. 50% of 45 is 22,500. Now we look at here. 22,000 do not exceed 25,000. Hence, you need not touch 25,000. It remains as it is. So this, I will tell maybe the idea. I will tell you what the idea behind this. Another example: 45,000. Then 50% is 25,000. That doesn't exceed 30,000. Hence, his wages and record is 30. Now, see, attention idea may be like this. Because what happens, in all the cases what we have seen, people, what they do is that they put on basic and DA, but put more money in the to avoid provident contributions, to avoid gratuity, whatnot. And probably the intention, the thinking was that. Because of this, you remember that I think about 3 or 4 years back, there was a draft amendment to PF Act was on the offing. There, instead of basic wages, they say it is contributable wages or something they called them. There, they mentioned the percentage. That should be 50% of the gross. They had mentioned at that time in the bill. Of course, it did not come through and then it kept in dark when it was over. Probably the intention of the government is that with a view to avoid the employers exploiting this kind of a situation, putting less here and more here, probably that may be the intention. But only they could have made it with a simple definition. The gross salary 50% just take it and pay PF. They could have made it, but unless this is complicated, but anyway, we have to go through this kind of thing. Chapter on minimum wages, of course, you know the wage theories, I don't want to take much time. The only thing is the living wage and need-based living wage. Here, 3 consumption unit, that's 2,700 calories per head, 72 hours per annum, and then house rent 20% total calculated other expenses. This is recommended by Dr. Arthur recommendation and are supported by ILO, and even Supreme Court also has upheld this. This is called need-based wages. So this is the base. Of course, the wage theories, what they say is that even right from fair wages, capacity of the employer to pay, that is kept in mind. But unfortunately, for need-based also, that is absent in this. Absent. It doesn't matter. So here, of course, you know that fixation of minimum wages in India is a very, very complicated thing because of various reasons, because various diversity. Conditions vary from place to place, industry to industry. Standard of living cannot be determined accurately. Then, no size of the family, what should be determined? It's a big challenge right from beginning. It has been facing you. Now here for in the now under the Payment Minimum Wages Act, we have got almost 2,000 different types of jobs for which minimum wages have been fixed in various sectors of industry. So there's a complicated issue. So in fact, in one of the questions raised in 2018 before the Parliament, the answer given by the government was that the wage ranges as low as 65 rupees per day to 300 per day. Look at this. This is answered by in the Parliament by on a question answered by the government. So look at the variance. So the major problem. Now here, the insight is that the Supreme Court also has said we'll fix the minimum wages and 2,400 calories, thereafter revised to 2,700 calories. They have calculated and do it. The committee also recommended lower calorie by citing changing literature, consumption patterns, reduce repetitive work. Now here in 2019, the government of India formed a small committee to understand how it does it work. How does it work, this formula? They worked on that. The committee worked on this in 2019, taking into 2018 prices. 18 prices, the minimum wages came to 375 per day on this formula. In fact, if you see that report, they have done a wonderful job in the sense that they have collected details from across the country. They have calculated what does a 2,000 calorie means, different places. They have done an excellent job, and then ultimately they recommended. But thereafter, they thought that we had to do on a national wage policy. Then committee recommended we had to make it region-wise, because what happens, one region will be totally highly industrialized. Another region may not be highly industrialized. One may be developed, another may not develop. He said that let's not make uniform, we'll make region-wise calculation. There. So the committee did also. If you see the region-wise, region 1, Assam, Bihar, Jharkhand, MP, 342 per day. Then AP, Telangana, Chhattisgarh, Uttarakhand, 380 per day. Gujarat, Karnataka, Kerala, Maharashtra, 414 per day. Then Delhi, Goa, Haryana, Punjab, 447 per day. Then Arunachal Pradesh, Manipur, Meghalaya, Nagaland, Sikkim, 386 per day. This is based on 2018 prices. 2018, just to get a fair idea, yes, how it is. This is good work done. Now, I think based on this, if the code comes into effect, if the government, comes through and start working on it, I think the activity will have to start. Of course, here, one major thing here is that in the present minimum wages, we have got categories of industries. In Bangalore, in Karnataka, we see there are about 73 or 74 different categories. Now, hereafter, the categories is totally eliminated. An unskilled worker means an unskilled worker with the same wages, irrespective of his industry where he is working. A person working in a hotel, he will get the same. Working in engineering industry, he will get the same. Working in a commercial establishment, he will get the same. So uniform minimum wages across. So this is a good, maybe an advantage, maybe disadvantage. Because what happens? Some industry affordability. Some industry may be affordable, some may not be affordable, but no objection have been raised, and the kind of thing today. Of course, there are no changes, otherwise no changes. Then payment of wages, except 24,000, they have removed it now. It means that all employees are deemed to be employees under the payment of wages chapter. Now here one dangerous thing, here under this code, under penalty clause, any employee, your trade union can file a criminal case directly on the employer for any violation of this chapter. Look at this. If your manager is not happy with you, he wants to take a grudge and you want to see, he can straight away go and file a case against the magistrate, against the occupier. Now, the dangerous provision made in this chapter, that kind of thing. Otherwise, now, salary should be paid on 7th day. Uniformly, it has been very clear, it goes on. And then, of course, payment of bonus, there are no changes, except the wage, of course. Same thing will happen. The payment of bonus, of course, they meant prescribed by the. Now we have to see, because for the last financial year, no changes were made by the central government. So 21,000 remains, and 7,000 are minimum wages, payable bonus. Now we have to see for this financial what the government is going to do. We have to wait and see. But other things are maintained same. The calculation of allocable surplus, what you call set on set off table, everything remains same. No change at all. Absolutely no change. Now here, the minimum, if they fix, it will be based on 1922 cost of living. In addition, DA will be revised every 6 months. Now, at least now it's 1 year, but hereafter it will be once in 6 months. So, minimum will be all scheduled and no classification. These are important impacts on the companies, and cost of contract labor also visibly might increase. Obviously, it will go up. And the huge liability on the employer and direct impact. And payment of gratuity, PF, etc., I told you already. This is the implication. Now, here the thing is, how do you take care of the additional liability on account of this? So, you have to go in for, you have to think as to how to control the cost of labor in spite of this kind of a reason. That's a managerial challenge once again. It's a managerial challenge. How do I reduce it? That is the kind of thing. Okay, now we'll quickly go through the IR code. In IR code, there are two important things I just want to share with you. What definition of workman, no change. Whatever remaining same thing, except that the salary limit for super people have been limited at 18,000 rupees. That's the only thing. Otherwise, absolute no change. Definition of employee has been added. I told you it includes everybody. But luckily, this word employee has not been mentioned anywhere in this code. That is the only thing. That is the only thing, the important thing. Otherwise, the manager would have been covered under this code and he could have raised a dispute. It is not there. Definition industry, here what they have to define industry, they have just taken the crisps of the judgment of Krishna here and then they put it here. In other words, same systematic activity, carrying out the cooperation of employee, blah, blah, everything. Same thing they are done. It's a good thing, so it's a nice thing what they have done. And of course, they have introduced fixed term employment, knowing it, just to take care of the sudden requirement of manpower on account of anything. But the only thing is, condition is that the salary and benefit must be same as what you give to permanent staff. No distinction whatsoever. You can't say a fixed term employee will give less. No, it's not permitted. You have to give the same wages and benefits you should give. And also, Even if you work for 1 year, you have to pay the gratuity. If you pay for 2 years, you have to pay the gratuity. There is an added thing what they have done. So, this is an advantage to employees provided they manage this properly. Manage this properly. Because what happens, here, number of terms of employment has not been mentioned. It is not mentioned. How many times they can engage is not mentioned here. Then that becomes an issue. Because what happens, if you go on renewing the contract year by year, year by year, year by year, in one of the cases, Supreme Court has said very clearly, this is nothing but an artificial creation of you because you want to deprive the employee to give permanency character. So it is unfair. So from that point of view, one suggestion is that maybe better to give 2 or 3 extensions, not more than that. Otherwise, this one. And secondly, there is also a logic. The fixed term employment trees should be related to the work, not to the employee. Because if you got a quantum of production increase and it lasts for 6 months, you have to correlate with that 6 months. It's not an employee. No, just because somebody is there, okay, I'll take it for 6 months. No, it should be related to the quantum of work, not to the period of employment. Otherwise, what happens? It may be argued as unfair labor practice. So this is a critical issue. We have to be careful on this. Of course, negotiating, I will come to that, unorganized sector, and this I will tell you. Here, grievance redressal, Works Committee retained, no issues on that. Then, grievance redressal machinery, this is a little complicated thing. No, this is exactly what I said earlier also. The maximum is 10. Let us say you got 10 people in the committee, five workers and 5 management. They got 10 people. No, let us say the grievance of an employee comes. Then the committee decides that, no, this is not a genuine grievance. We have to say no for this, for these reasons. That decision has to be passed unanimously by the committee. And they have put a clause, provided at least 50% of those people should endorse here. So it means that at least 75% of the committee members should endorse your decision. Practically, I tell you, it's a very difficult thing. Unless you got excellent industrial relations. If you got good industrial relations, yes, it's possible. Suppose you don't have a good industrial relations, the union will say, sir, I will not vote. Let him go to conciliation. Let him go to raise a dispute. I will go and dispute. I will not agree for this one. But if you got good relationship with the trade union, then what happens? You can convince him, take them into conference and pass a resolution. So this is a very tricky issue. If you don't do this, your, disputes will be multiple disputes. Multiple disputes go like anything. So, you have to have it. Equal, I told you already. Here where you play an important role. The grievances must be settled at the shop floor as quickly as possible. It should not be allowed to go to committee at all. The moment you see a grievance, settle it by all your methodology of soft skills or whatever you may call it. You have to settle it. Otherwise, if the writing goes to committee, then you're out of your control. So you should be very careful and cautious in doing this. So forecast the grievance and take preventive steps. This is the managerial effectiveness. Then also we should keep it in mind, this is one of the tools for developing employee relations. Because if you do it in a fair and legal and justifiable manner, if you take people into confidence and take it, then what happens? This is a step of developing good employer-employee relations. This is one of the tools of employee relations. Always keep it in mind. This is very useful. Next point to be this one is that the mandatory thing has come now. Earlier we had public utility services. You may know that is eliminated. Now it is 14 days is mandated for either strike or lockout is a must. Without notice, it is going to be illegal. So, and mass casual leave, if 51% the workmen go on leave, it is deemed as strike. It is deemed as strike. There is something is added. Otherwise, nothing much. Here, first time after 94 years of independence, the status of recognition of trade unions has come into play. Actually, 1935, you know, the act came into force in 1926. In 1935, they tried to amend the bill. Everything was ready, but somehow it was kept in cold storage. And in the late 70s also, they prepared a bill and nothing happened. So, keeping quiet. But now today, at least there is some regulation to see that recognition, giving according to this one. And standing order applicability has been announced to 300 as against 100 across. There is slight relief for lay of retrenchment and closure. Now, 100 has been enhanced to 300. There is only small relief for the employees as far as this is concerned. I hope it will not be touched again. That is the only thing. Till the code comes into effect, they should not amend it, say we can make it 100. That should not happen. We have to hope for it. Trade union recognition is very clear. 51% above, they shall be recognized, there is no doubt. If there are multiple unions, then the employee shall ask for details. And if the details furnished to the employer is not acceptable for various reasons, he can refer the matter to the registrar of trade unions. Then he will examine the whole thing. Then he will allocate the number of members based on at the rate of 20% as one. So it means what happens is the council is formed. This is called bargaining council, and they will be just like a recognized union. They will negotiate the management and all that. So this kind of system has come up with detailed rules have been made on this respect, and then this is a positive thing it has come. Now, otherwise, all other provisions of Trade Union Act is repeated. There is no change at all. There is no change. Under this chapter, worker includes all persons employed in the industry. Can you tell me why? Worker means all persons employed in the industry. Tell me the reason why. Just verify Article 19(1) of the Constitution of India. What it says? It is your fundamental right to form a union. Being a manager, you are not prohibited. You can form a union. That's the reason why they have used the worker includes all persons, means including everybody. Because the fundamental right guaranteed in Article 19(1). So this is the reason of inclusion of this one. Okay? Of course, the standing order I told you already. And certification should be done within 90 days. This one radar has been put. But practically we have to see how far it really works. Because now, you know, certification takes even 3 or 4 years or 5 years before the Labor Department. Nothing happens. But now here, 90 days they have put the plug, but we have to see how it happens. But there is one little small provision in the sense that if the draft standing order is exchanged to the union or the negotiating council, and if you both of you come to an understanding, you can submit a memorandum so that the certification becomes easier. That's the only thing. Of course, in Karnataka, we have that provision already, understanding order, we have that. But here also, I think the session is there, but we can encash it. Otherwise, all the existing standing order provisions, same thing continues, no change in it. But Section 9A, no change, I told you already, except some few exceptions are there, it's of no use. In fact, we are already doing it. See, for instance, you know, in case of emergency situation requires change in shift or the standing order, consultation and grievance redress committees are there. Now we are doing it. Have you not done it, our rationalization, automation in 1991 when we brought this? Have we done the same thing? What we have done, we've taken people to conference. Without getting into complication of Section 9A, we have implemented the changes. There is nothing new about it. So in other words, the spirit of prohibition still continues only. There is no change in it. Of course, voluntary reference of dispute is only same thing is continued, no change in it. And conciliation, there is slight change. Now today, what happens? The conciliation, the failure report shall be submitted to the government. The government shall refer it for adjudication, either for labor code or whatever it is. Now what happened is that there is slight modification. The failure report shall be made. It shall be submitted both to government and both the parties. thereafter it left over. It is up to the parties to go to adjudication. If the union wants to take, they can go straight approach the adjudication. If the union management wants, they can go. If they don't, both don't want to go, nothing, no reference at all. So this one way of cutting it a what you call bureaucratic step. That is one is law change. The other thing is right now, you have got industrial labor courts are abolished. Hereafter, no labor courts, only industrial tribunals. In tribunals, now today we have got one judge. Now here it is a bench of three people, two judicial and one non-judicial. Of course, the rules have been made in detail, how should you appointment, etc., etc. But this is one small change, but we have to see how far it works. We have to wait and see. Otherwise, all the things are fully completed. Lay of retrenchment, I told you, it is less than 300, you need not take permission. But of course, compensation is a must, that everything is intact, no change in it. And 300 more, then again you have to go for permission, same thing. And here, of course, naturally, IT, ITS, BPOs are not covered because definition of industry is only factory, mine and plant. Right? Even now, the same thing is being continued. That's the only thing. Otherwise, no other things are changed. And reskilling fund, they have creating a fund. But the one funny thing is that in the draft rules, what they have made in this, the intention of the government is to create a fund to train people or to keep a skill to people who have been retrenched. That's the purpose. But now in the draft rules, it's totally different. What it says is that if let's say you retrench 10 people, then 15 days salary per year of service you have to give. That 15 days, 15 days salary, you have to remit to the government under here. And the government will transfer this money to the retrenched worker to the respective bank accounts. In other words, instead of asking employer to give, in addition to compensation, give another half a month salary, this routing is done. We don't know why. It doesn't serve the purpose. Anyway, let us see that. All other things are remain changed. That is approval of action taken for dismissals and you got section 33 2B, 33A. Everything is same, no change in it. Everything is same thing. And protected workmen, process and this, that's also remain change, no change in it. Absolutely no change. And representation, concession, everything is same. Absolutely no change in the entire thing. Now here, one advantage is that definition of employee, word employee is not included here, so we are saved. That's the only thing. Free approval, 14 days notice, a limit for application standing order to enhance. There's a few advantage points for the employers. Now when you come to social security scheme, now here one thing I can tell you that here not many changes are there in all these 5 acts, not many changes. So we did not spend too much of time on this because absolutely no change in it, except small changes here, there, otherwise no changes. Everything remains same. And only thing is, instead of employment exchange, they call it as career center hereafter. Career center, and you have to send the returns. Otherwise, no change in it. Definitions, same thing. The legislation, no change in it. Here, only one thing is a contract labor, there is slight change. What they say is that contract labor includes interstate migrant workers. So, this is one implications we have. So, that one, I'll just talk to you on this. Then here, fixed home-based workers, self-employed, and organized workers. These are the included in the code. And of course, here, social security scheme. Right now we have got Provident Fund organization, ESI organization, all this. Same thing will continue, maybe with different rules or scheme may come, otherwise remain same, no change in it. Provident Fund, of course, section there said that the contribution in respect of contract labor shall be paid directly to the PF Commissioner and you can recover from the contractors. Even now it is there, but they are reimbursed later. Here, only one change is that the employer-employee contributions to 10%, but however, the government has got powers to keep it at 12% also. This we have to see how far it works, we have to see. But of course, we can't, if you are already paying 12%, How can we reduce to 10% on account of this is a big challenge. Is it going to be a big challenge? Probably the government will say those who are paying 12%, that will remain. Probably that will be the notification of the government. We have to wait and see. Otherwise, no change in it. Then ESI, no change at all. Everything is remains same. If only one change is there, the liability of owner. If the sickness benefit or the accident, whatever it is being paid on account of the unsanitary, unsafe conditions maintained in the factory for which employee is responsible, then the amount paid to the ESI employee shall be paid by the employer to the ESI corporation. Suppose there is an accident, right? And the ESI takes care of everything. And on account of inquiry, he finds that the accident happened on account of your unsafe conditions. You're not taken care of properly. There is the fault of the management. He says, why should I pay? I have paid it, you give me this. So this is one thing which has come here that we have to be very careful and cautious. Gratuity, no change at all, except that I told you fixed term employees had to pay in proportion. Otherwise, absolutely no change. Material benefit, no change. Everything remains same. And Employee Compensation Act, no change in it, absolutely remains same. Then it says in the building and construction workers says, is also no change in it, everything remains same, absolutely no change. Now here, of course, for unorganized sectors, the emphasis to look after the life disability cover and health, military benefit, old age pension, education, housing, etc., at disabled one, this has to be provided. Now here, who are the unorganized sector? Who are in the agriculture, building and construction industry, BD industry, handloom, power looms, fishing and processing, then toddy tapping, head load workers, railway porters, agarbatti, rack pickers, rickshaw pullers, salt workers, carpet weavers, leather workers, and the like. These are all the what you call set of unorganized workers they have classified. Of course, for this again, the state government also will formulate a scheme. Based on that, it has to be done. Of course, now probably you know that in 2017, in this bill, there was a proposal to make the scheme as universalized. It means that they want to cover the unorganized along with the organized and give a common code number. Just you see now we got Aadhaar card. Like that, they wanted to issue one card to all the sectors of people and single window approach. Single window for PF, ESI, gratuity, bonus, whatever it is. A single window. It means that you go there, submit it, you get the money. And the employees shall pay clipboard, whatever it is. But luckily, this was given up by the government because what happened? Organized sector consists of how many? Only 6 or 7% of the population. And only hardly 6 or 7 crores of people. Whereas unorganized sector, it consists of almost 25 to 28 crores of people, even 30 crores. So as it is, we are finding it difficult to get the benefit of PF, PSI with this arrangement itself, people finding it difficult. And how can NMPG manage with a big population of 35 crores or 40 crores? This became a debate, and then luckily they kept it in cold storage and leave it at that. Now probably they will concentrate for unorganized workers separately. That's fine. They must do that. Of course, funding is only through all these things. Employment exchange, I told you already. The system continues. Returns filing, everything continues, but it is called centers. Career center. It's called as career centers. Now we come to the last code of safety and health conditions. It is a consolidation of 13 legislations. 13 legislation. Of course, it will focus mainly on factory side because most of us are connected to the factory side. These are the act have been consolidated, 13 legislations. And of course, one thing is that the code is applicable to all the establishments. Even IT, BT, everybody is covered under this because what happens, the intention of the government is that to provide the health conditions, safety conditions, hazardous working conditions, whether he is working in a factory or commercial establishment doesn't make, he must be taken care of. He must be taken care of. That's the intention. For this purpose, they said they are applicable to all the establishments. That is the reason what they have done in the code, Look at definition, registration, duties of employees, occupational health and safety, welfare, etc., etc. Employment of women is applicable to all the establishments. The second chapter, contract labor, applicable only for this. Mines, cigarette, BD and cigar, then building and construction, factories, separate segment of industry. So here, this is a distinction has been made in this code. Of course, there are some complications likely to come, but we'll see how it is going to be addressed. Of course, the definitions are same, no change in the entire thing. But here, there is one change I told you already. Definition of migrant workers means who is recruited by, look at this, an employer in one state for employment is established in another state, or through a contractor. Now, present condition what? Second. Definition of migrant workers is now applicable as a second category. It means that a person employed, a set of people employed by a contractor, they are called as migrant workers. But here what happens? They put an employer in one state for employment is establishment required. Supposing I recruit 10 people from Andhra, 10 people from Maharashtra. Under this, they are also called as interstate migrant workmen. Under this. Now here what happens? The obligation of employers will be again more. Again more. This is another peculiar thing. Of course, here the everything is same. Definition industry same thing. Worker same thing. Employees same thing as I explained to you already. Now contract labor. This has been defined, but there is one little exception. We have to think on how to make use of it. Contract labor. Whatever does not include a worker, look at this. Other than part-time, who is regularly employed by the contract in any activity in his establishment, his employment is governed by mutually accepted standards of condition, including engagement of permanent basis, and he gets periodical increment in the pay, social security coverage, and other welfare in accordance with labor time. He is not a contract labor. Now, this point may be a debatable point. I'll tell you a simple example. Let us take team lease. Right? Team lease. What is the nature of business of them? Supply manpower. There is a business. Right? Now, they issue all this taken care of. Letter of appointment, they cover ESAPF, they maintain everything, they do everything, they manage it. And if you say that I want 10 people from team lease, they give you 10 people. When you come to your, at present, they come under Contract Labor Act. But now with this interpretation, they say they are not workmen. So why do I will not register, I will not take license. So this is a debatable point. We have to see how far the judiciary looks into it or anybody looks into it, the matter of this one. But I think probably the intention government also may be that we don't know. But when it comes into effect, we have to see whether this argument will hold good. If it doesn't hold good, then it's finished. It is finished because there are section 57 of the code is dangerous again. I will just tell you. So here they have defined for the first time what is core and non-core. They have defined. And here core activity means, look at this, it's a very vague definition. Any activity for which establishment set up and include any activity is essential and necessary for such activity. This is a very, very wide meaning. Now again, I tell you, friends, this leads to lot of litigations. Lot of litigation. The other day I was talking to some people in a conference. You see, take for instance, in a shop floor, you got bay number 1, you got bay number 2, you got bay number 3. And then the components, from bay 1 to bay 2 shift, B2 to B2 shift, we have to do it. So what happens now, probably loading and unloading under question, we are engaging contract labor. What he does, he takes the component here, delivers here. He takes the component from here, delivers here. Now the debate is whether that activity of taking the component from here to here, here to here, is it core or non-core? It becomes a big debatable issue. We say, no, it is non-core. Suppose for argument's sake, we say it is non-core. But the union will say, nothing, sir. Look at the definition. Essential, necessary for such activity. Supposing you don't transfer this component to B, you can't make the product. It is gone. Without this activity, you can't survive. Without this activity, you can't finish your work. That will be the argument put by the union. This will be the argument. So this is a very debatable issue. And for this, there is one peculiar thing. They have made a provision. If there is a doubt, whether it's core or non-core, you can go to you can go to authorities for resolution of dispute. Then what happens? That will be a matter of debate and discussion and litigation, whatnots. Then what happens here? What is going to happen in the industry? Are you going to litigate it? What do it? Now, this is a very, very challenging thing. It is yet to say that whether it's comfortable or not comfortable on account of the, we have to wait and see. When it actually happens, you have to wait and see how the trade union looks for and how the judiciary looks for, how the interpretation holds good. It is a big challenge in this activity. And of course, they have defined non-core activities, very easy. All this sanitary, including sweeping, cleaning, watch and ward cleaning, all these things, they're defined non-core. They are a safe thing for us. It means that we can engage contract labor for non-core. There is no problem. Here also, courier services, civil construction work, gardening, housekeeping, laundry services, all these things, they play non-core, no problem in it. Then here I told you already, appoint an authority to decide. The agreed party may make an application in such form, may prescribe the in this direction, and he can file a petition. So this is a most delicate and a dangerous issue, what we are going to face, all of us. So this is a concern. Of course, the other things are very necessary. Duties of employees, they said, it's the responsibility of the employer to maintain. So, as what we see in Factories Act today, same thing is repeated. The employee shall be responsible for all this, all this, all this. Same thing is repeated here. Heavy responsibility is put on the people. The National Board also will fix the rules and regulations in pharmacy, implementation pharmacy code, and a copy of program related to all these things. Right now, whatever we have now, same thing is more or less continued, no change in it. Welfare facilities, as it is in Factories Act, same thing is repeated. The employee shall be responsible. He has to take care of it. Now here, daily working hours, compensatory, shift lines, all these things. The only thing is the annual eligibility will be reduced to 180 days from 240 days. Now today it is 240 days to eligibility get the annually, but now they are reduced to 180 days. Maybe it is beneficial for the workman, no doubt about it. Then here they have put this one. This we have to see how far this whole good way to wait and see, because a lot of debate is taking place. Working hours shall not exceed 48 hours in a week. Working hours. But the period of work will show arrange that the spread over inclusive restriction shall not exceed 10.5 hours a day. It means that the spread over is inclusive of your spread over time. No, there is also debate that working hours, 48 hours, is inclusive of restrictive. There was an argument put by them, but somehow I think it is the. And yesterday also there is some news item saying that the spread over may be extended to 12 hours with a view to reduce the working hour from 6 days to 4 days. The item. So we have to wait and see how it comes. It is too early to comment on this, but we have to see. But the spread hour shall include lunch hours. That is one important thing. Now here, one good thing is that annual health checkup for those who have completed 45 years. And it is a must once in a year by a qualified medical officer. And every worker should issue a letter of appointment in Form X that they have made, like what we see in shop and establishment today, Form Q. Here also they have said Form X should be issued to everybody. And service certificate should be mandatory. On cessation of employment, you have to give it. Then it is the duty of any worker to notify the concerned safe to any unsafe or unsafe conditions issued by the notice by the worker. You know it is there in the Factories Act. This is not nothing much. Here there is one small rider, overtime. Provided no worker shall be required to work overtime by the employer without prior consent of the worker in writing for doing such work. Now, this is a major heck. Suppose you want to book people on overtime, unless you give his consent, you can't ask him to work. You can't charge him, you can't do anything. In standing orders, we will have got refusal of overtime is a misconduct. Hereafter, it's a gone thing. So it means that you have to take consent of the worker before booking an overtime. Now, this is another a major issue or a challenge which are going to face it. This is one thing. Employment, of course, these they have liberalized in the sense that you can engage, but provided the security. All these things have been mentioned in the rules that what are the security guards to be taken into account. It has mentioned there, you have to take care of it. Then contract labor, right now it is 20, 20 has been increased to 50. That's the only thing. And license, of course, it will be a work-specific license of the contractor. It is not there. Then a lot of, in the rules also, they have made specifically clear that the contractor has to provide the contract, etc., etc. And you should work-specific contract. Housekeeping means housekeeping only. Security means security only. Now, we mention production-related activities that we are going to mention many times. Now, hereafter, that will not be there. It should be work-specific. What is it you are going to do? You have to mention it. So, that is going to be this one. And of course, non-licensed contractor, if you engage, it's going to be illegal. Even now it is there. The same thing has been repeated here also. Now, right now we have got section 10 of the present contract labor, prohibition of contract labor. In prohibition contract labor, the big process. The petition has to go before the advisory board, advisory deliberated, and they have discussed, study, and make a recommendation. The government may accept or may not accept. It takes a big exercise of almost 1 to 1.5 years. In fact, when I was in Kirloskar, I had an opportunity to represent the employers in the advisory council. In fact, 3 cases are referred to me. I was appointed as the chairman of the subcommittee. And then in 2 committees, being a chairman, I have recommended it must be abolished. I have given a recommendation. In one other thing, not necessary. In fact, one of the trade union leaders told me in the conference, in the meeting, he said, being a management representative, you have supported us. Provision required, I really appreciate you. Because these are based on facts, nothing else. This is a process. But now, friends, under section 57 of this code, notwithstanding anything contained in the part, employment of contract labor in core activities is prohibited. Totally gone. Now, no need to go to board and all, it is already gone. It is straight prohibition. Straight prohibition. Now, when the code comes into effect, actually we have to see how the company is going to manage and how the unions are going to take it up, how the agitation will start. We have to wait and see. Because just waiting. Because when they know that there is total prohibition, except non-core, of course, no problem in it. In core, I told you the example of this one. Small issues. This became major issue. Now, today, for instance, now, you take any automobile sector like Honda Motors and everything. There, the proportion of contract labor employed in the production area is almost more than 40%. If 40% is prohibited, how the industry will just collapse? Either they have to absorb them or they have to close the industry, whatever it is. Now, this is a very challenging issue for all the managements. A very challenging issue. We have to wait and see how things goes on when we can't predict anything. We can't predict anything, but this danger still remains. Of course, some exceptions are there. Except normal function establishment in such activity, ordinarily done through contractor. Maybe we can take some leverage out of this. Or activity that required full-time workers for major portion of the working hours in a day. Is all we can take a plea, but it's difficult to hold on. Sudden increase in the volume in core activity, of course, this is permitted, but you have to prove. There is sudden, you see, today I'm making 10 components, tomorrow I have to make 20 components for 1 month. So 1 month, I can engage contract labor in core activity for 1 month. That is permitted. So again, it's a very, very tricky issue and we should be done very carefully and cautiously. Interstate migrant workers, it's the duty of every employer to take care of everything. Interstate migrant workers, many of the responsibility put on the contractor. But now, it is directly on the employer. That is the kind of thing. And displacement allowance, the journey allowance, and even what you call accommodation, place of residence is also provided. Now, I told you already definition of interstate migrant industry, it includes direct recruited by the employer also. So, does it mean that if I include 10 people from Andhra, I have to give residential accommodation here. So these are the questions likely to come. Otherwise, the Factories Act, everything is scheduled remains same, no change in it. And here, this is also where to the point to be noted, OT alliance. See, right now, the overtime we are paying on the, as per the definition of ordinary rate of wages, we are giving the overtime. It means that whatever we earned for last 3 months gross salary, based on that, we calculate and pay on the basic day and allowances. Now what happens? You have to pay on the definition of wages. So obviously it will be less. It will be less. Now, is it a matter of concern that this also we have to wait and see how the people react to it or how the people respond to it? We have to wait and see. This is another big challenge. So the rules is going to be voluminous. There's no right now the draft tools have been published and Mr. Govindaraj already done a lot of work on the draft rules. It's a big voluminous. If you want to see factors and rules, you have to see big volume. It contains all the rules concerning all 13 acts, 13 activities. And you have to go on searching, oh, Factories Act, where is it here? So you got a big volume, it's a very, very messy thing. So, gentlemen, now this is the in short presentation I made on the four course, very quick short. I've done my level best to present to you. But on the whole, I can say, of course, don't think I'm prejudiced. This is not employer-friendly course. That's all. The other day, I was addressing a trade union leader for the first time, just last week. Trade union leaders wanted to know the labor code. The first time the unions have come forward to understand the code. So what I did, I told them the plus points of the code. So they were happy and thrilled. But now today, yeah, still agitate. There is no doubt about it. There is no what you call limit for agitation. It goes on, goes on. But on the whole, I can tell you this code is not friendly. One more point I want to tell you. You see, if you read the Factories Act, even today, it is a fantastic act, I tell you. Fantastic act, Factories Act. Beautifully drafted, with each and everything into account. Even in spite of our modernization, even in spite of our latest machinery, still the provisions of Factories Act holds good, though it is done in 1948. Beautifully done. The moment you read a Factories Act, you get some kind of a fear and anxiety. Oh, Baba, I have to do this, I have to take care of this, I have to do this, I have to do this, I have to do this. But here it is totally absent. They say, for everything, refer rules. For everything, refer rules. You see, what happens, the spirit of this one is totally narrowed down now. I to rules, yeah, doesn't matter. Oh, rules says, oh, that kind of dilution takes place. Suppose you act itself, no, act says, we have to do this. Here, the rule says we have to do it. So it mitigates. And secondly, if you have read building and construction workers, I tell you, there's one of the superb act I have seen. Look at the safety regulations in the building and construction workers. It's one of the excellent topic. Another excellent. They have made it details right from laying the foundation up to the end level of construction and building. Every activity has been mentioned with safety measures, beautifully done. But today, no mention in the code itself. They say refer the act. Even rules also, nothing much is there. So it is totally diluted. So this is the problem. Anyway, these are the negative facts of labor code. But yesterday somebody was telling me that code may become effective from 1st July. We don't know how far it is true because nobody is prepared for it. Somebody was telling me yesterday, somebody sent a message from October. Nirmala Sitaram has said that 1st October will bring this thing into effect. I don't know how far it is true, but wait and see. Behind it, but the rules are still not done. Reaction. But everybody is keeping out, And everybody is silent. There's another unfortunate thing is that everybody is silent. But we have to see. Friends, my suggestion is this. If you want to be thorough with the code, conceptually understand each and everything, you follow these steps. Please read the labor reforms, in short. Then conceptually become very strong in your ideas because beautiful. The commissions appointed, I told you already, they have done a wonderful job in putting their findings in the commission report. Secondly, the commission report, right, the same thing. And the next thing is be thorough with the existing laws. You see, today I skipped no changes, no changes, no changes. You should not get a, you should dilute it yourself. Of course, today for entrepreneur, you say no change. That is not the correct thing. You should be thorough with the existing laws. Then, third step is that you read the law, you read the labor code. Then you will be very strong, conceptually strong in your understanding. You can enhance your legal competency in the field, legal competency. That's very important because there is a lot of problems and issues. You should be able to debate it. So let's say for example, contract labor, I gave the example of non-core. And contract labor, whether manpower, whether the team is supplied by is this thing or not. You have to debate. You have to debate with the top management. You have to do it. Or you have to debate something. You can't say everything. No. Let me call a consultant. Let me call an advocate. No, there is not a thing. You should be able to debate yourself and understand and advise the top management. I said, this is it. For this purpose, you have to increase your competency, enhance your competency in legal competency, then you'll be more strong. So this is exactly what I have done. I don't know how you liked it, but anyway, I've done my level best to tell you this.
If you have any questions, you can ask Vittal Rao sir.
Good morning. Vittal Rao sir, first of all, thank you for sharing the knowledge base, which just today we leveraged the complete statutory part and the law. I have a question for you. In your session, you told that we need to take a consent from the workers to carry out the OT, right? Is it a everyday consent we need to take, or it will be part of the appointment letter?
No, not part of the appointment letter. In appointment letter, it may be there. In standing orders, it may have. But what they say here in this provision, without consent, you can't do anything. It means that if you have to do it daily, you have to do it. I think so. But practically how it happens, we have to wait and see. But just because in a standing order, just because appointment letter, you can't take it for granted only consent is given. There's a condition what you have put. The workman shall not refuse to work overtime. That's the condition what we are going to put. At the time of signing the appointment, he may sign. That's a different issue. At the time of implementation, he said, sir, I have to take my consent. Today I can't come, sir, I got some work. Tomorrow I can't come, I got some other work. This is a practical problem it will come.
Because I come from a FMGC food processing industry. Mm-hmm. So whenever the operator doesn't come, there might be absence without information also. So during that time...
For that there is a provision in the chapter. If a shift worker is absent, then the second worker can be put on overtime. That is there. But here what happens, the consent of overtime means he is work for 8 hours and afterwards you want to work him for 3 or 4 hours extra. For that it is required.
But there is no provision for continuous work of 8 hours again.
I don't think so.
Because shifts, it's like 8 to 8 for us. 8 hours continuous shifts.
8 hours. But there is a built-in provision. If a shift worker is absent, you can always engage the other worker to ask him to come. That is not touched.
Okay.
But here, this is good. Now again, you tell you this new thing, these are all subject to interpretation. Today I can say that he has to take it. But we have to see how the factory inspector look at it or how somebody looks at it. It's a matter of, again, interpretations. That is the kind of thing. But today I can say, if provision is there, you have to take consent.
Okay. Sir, I have a second question for you. You told the wages need to be 50% of the gross wages is considered as basic and DA, right? So does it had any impact on your gratuity payment?
No, definitely. I told you, that wages. You see, the thing is, you don't have to modify your salary structure. It will be treated as wages. Don't say that you would add on to basic and DA. It doesn't say that. This portion is considered wages. It's a notional adding this amount to basic and DA for the purpose of so and so. So, gratuity definitely it attracts.
And what about the PF, sir? PF also it is again 50%.
Yeah, PF, then bonus, gratuity, it automatically applies.
So ceiling amount will go 15,000 what we are ceiling right now to pay the PF contribution.
Right now it is there, but there is a rumor that they want to increase PF limit to 21,000. Their likely move is there. Even last month there was a strong message. It will enhance shortly, but even they are keeping quiet. because probably I think there's a lot of effect they are keeping going. But they may be, it's a question of time. They may announce it.
Thank you, sir.
Thank you.
Yeah, hi sir. My name is Praveen. I'm working for BCP Associates. So I'm not sitting in the BCP office. I'm sitting in the client place. So I'm handling compliance in the client place. Sir, I have a question. So SND Act will be repealed.
Hmm?
SND Act will be repealed.
Oh my God, that is a big question what you are asking. I will tell you, you see, Govind, you may recollect, we had drafted, we gave our comments on the draft rules of code in wages to the Labor Department. They had called for a conference, to hear their objections. In fact, I was also there. In fact, I made a point to the Labor Department at that time because many of the provisions of Shop and Establishments Act is being addressed here. Appointment letters, working hours, holiday, whatever you name, everything addressed here. And registration also addressed here. Then where is the question of Shop and Establishment Act? Why not you move the government to repeal the act? Repeal the act. But of course, nothing happened. But I say, you already said, it's really a complication because I tell you, Shop and Establishment Act, you have to go and register.
Yeah.
Under this code, again, you have to register. Now, that is okay. Then you have to issue Form Q here. You have to form something here. The leave may be difference. Which is beneficial, you can trespass here. I think this is a little complicated. But right now, we can't say it is repealed. We can't say that. But this is the practical issue which people have to address it. In fact, the very, very valid question you asked, very valid. And we have to wait and see. That's all. I mean, right now it is not repealed.
Thank you, sir.
I'm Ravindra. I'm also a consultant. Basic wage is 15,000. Allowance is 10,000. So as per the new wage rules, the basic pay will remain 15,000 only.
Yeah.
What about the notification issued by Labor Department? The minimum wages for a highly skilled will be 17,500. Now, will that 15,000 will be remaining or 17,500 minimum wages?
Now what happens is that the minimum wages, let us say 17,000. PF is limited 15,000. And if your employees you are paying only on 15,000 right through, you can continue to pay on 15,000 only because the 15,000 is governed by Employees Provident Fund Act. You got
Sir,
it?
No, I'm not talking about Provident Fund. Minimum wages itself.
I know, your
See,
minimum
skilled,
wages
highly
is
skilled,
17,000.
Yes.
So should I contribute on 17,000 or should I limit?
Not PF contribution. 17th wages, which one I have to show? Basic and dearness allowance.
Huh.
Which one I have to show? 17,500 or 15,000?
For the purpose of?
Minimum wages.
Oh no, purpose of minimum wage, you can't take that because the minimum wages definition is already very clear.
Correct.
And then they have prescribed 17,000 minimum wages, so and so, so and so. Then you can't say I'll pay only 15,000.
Now I'll have to pay 17,500 there.
Yeah, definitely, no doubt. There's no doubt.
Okay.
There's no doubt.
Thank you.
Sir, myself, Dharnesh Kumar. Sir, if you go through each law, there are different objectives. Those objectives are framed as per the past scenario. Whether this objective is going to change in the present wage code, the labor code.
In objectives here, what is the objective of labor code? To ease out the business and reduce number of multiple registrations, and then reduce number of returns, etc., etc. Reduce the number of definitions, remove the interpretations unnecessarily. This is the objective of the labor code. This is the objective. Now, whether the objectives are being addressed, we have to wait and see. Because ease to business, if I see all the negative points, can you say it is ease to business? Because a lot of restrictions on you. Lot of restrictions on you. For each grievance redressal, you have a number of petitions going. Isn't it? Then recognition of trade union, that the matter will be decided by the Labor Department. Again, the matter of this one. And another thing is that in the draft rules of the IR code by Karnataka, they have suggested more activities into the ambit of trade union and the facilities to be given. Further, of course, we already filed the objections. There, they have said even increment you can debate, promotion you can debate. Now, today, what we say, increment is not a dispute because it's a managerial activity. In the Supreme Court has said, promotion you can't interfere. It's a managerial. But today, the promotion and increment as a dispute with the union can take. No, where is going to stand? And facilities. Today, we are very strict. Anything inside the company, no. You have to do outside only. But here it says, the management shall permit to hold meetings in their office, whatever it is, with permission, they have to hold the office in the premises of the factory. So, if all these things happens, it's on contract labor, I told you already, big prohibition. And then the cost of wage, I told you already, it is going to beyond a limit. And every DS 6 months revision, it goes up again. And you don't have any relief under Section 9A, no relief. Rate of retrenchment closure, except at 100, 300, otherwise not much. So if you see all these things, the ease of doing business shows the negative on number one. Number two is that registration. Now here also we have to see what exactly happens in the rules. One time we say that if you have registered an employee provident fund code or ESI code, that is deemed as registered on the code and you did not. So that is not very clear, we have to wait and see. In factory license, you have to take a factory license, you take a factory license and you have to register the code and what. So that way it is not this one. And interpretations of various clauses. Number of definitions are reduced, no doubt. But interpretations, I think according to me, interpretations will be a more thing because the examples I told you, it is not that. So the objective of this code is this. But how far it is addressing is a big challenging issue, this kind of thing.
Okay, thank you, sir.
So in contract labor, they have defined core activities and non-core activities. So mainly in the IT industries, for example, I will take one company named like IBM.
Yeah.
So they have outsourced their software development and other things to the Infosys or TCS.
Yeah.
So in that case, how the IT industry will survive?
It's the same problem there also. Because the IT industry, what happens, in a big floor like this, one team of outsourced fellows, they will be working. In another team, in the corner, another team is working. And here, your team is working. Now here, there are two things will happen. What is the nature of work and salary? Your company person, he is getting, let's say, he is getting 50,000 or 70,000, 80,000 rupees. That contract outsourced fellow, he is getting only 20,000 rupees. Nature of work, what? Almost similar. He also develops. Now there is another contravention because it says that the contract, there should not be distinction between as a pay is concerned, same thing should be paid, not one dangerous. Second thing is coming to core and non-core. No, this becomes a highly debatable issue because what happens is that the core activity, absolutely core activity, is then the only thing what we can take is that if the agency is like an establishment like Team Race and they have done that, maybe one point of argument you can take, number one. Second thing is, one other thing is, if you convert the contract into contract for service, not contract of service, if you make it a contract of service, maybe slight difference you can take. Otherwise, it's very difficult. In software, it is very difficult, I can tell you. That's why I don't know. In fact, I made a big, appeal letter to software companies. Please take it up with the government right now, because nobody bothered about it.
So in the contract labor, you have mentioned that core and non-core activities, which has been predefined by the Act. If you ask industry differs, non-core and core activity differs, right? Yeah. So for me, if you ask, inspection is a non-core activity for me. Sorting is a non-core activity for me because I am into a seasonal industry. Is there any provision which allows the employer to declare to authority that these are the non-core activities and these are the core activities under the Act, under the code?
You see, the decision of core and activity, you have to do that as management. You have to define as this non-core activity is the core activity. And you go as per that. Supposing the question comes, sir, you have declared this a core activity as a non-core activity, I will not agree, it must be a core activity because they got their own logic. When that question comes, if it goes to authorities, it's a matter of argument, litigation, and whatnots. So here, there is a very ticklish issue, I can tell you, very ticklish issue. Each activity, previously, word of inspection. Now, without inspection, can your product be dispatched?
Sir, but again, we cannot give the employment for 12 months. It will be 3 to 4 months in a year. So employer cannot pay for the full year. I cannot engage a full-time worker for 12 months and give wages where my activity is only 4 to 5 months.
Now, then what happens is that becomes the intermediate working. It means that you engage people for intermediate. For this also, you are governed by that. You are governed because just because you are intermediating in a way, you can't say, okay, this is non-core, I am doing it. No, you can't do that. Maybe one leverage you can take, what is that was that, on account of increase in volume, on account of seasonal factory, I am engaging for them for a period of 6 months or 8 months. Hence, this falls under non-core activity, hence the exception category, then I can carry on. You can use that logic depending on that. Maybe I am just telling you, but you have to debate it.
But whether we can win to submit a memorandum or something to the department setting that
No,
not
now. Unless until the issue rises, don't do anything.
Okay.
Because if you submit a memorandum, then you are just opening a Pandora box.
Okay.
You should never do that. If anybody asks, develop the logic. Okay. If you are asked, otherwise carry on. Here, one thing what I can do is because since you are in HR, what you can do is that please anticipate such issues and problems right now. And then prepare yourself. What is going to be my defense? Supposing this activity is non-core according to you, and they argue is core. What are your defenses? How do you justify right now? You prepare your arms and keep it in your back. Then it will matter of surprise.
So right now we are every 180 days we are giving breaks and we are creating new numbers. So that is the only option left for us. And we work in 2 seasons, 3 to 3 months maximum. So that option we are following. And appointment letters we are changing, the employer numbers we are changing. That we are following. But at the nook and corner, we are not able to give the gratuity because again we are changing the employer numbers. Employer at loss. Employer might be gaining, but employee at loss.
Yeah.
Okay. And one more, sir. There are few industries which run with the contract labor only, except manager staff. Few industries run with the logic of 10% of total force, few with the 50. There is no specific percentage defined in any of that. Do any code mandates that you need to have so much of permanent workers under any factory?
Nowhere it is segregated, nowhere it is defined. It's purely facts of life, facts of this one. Let us say, for there are many companies, they engage only managers, but engage contract labor to run the factory. Now, when the code comes, there's going to be a big challenge. There's going to be a big challenge. For that, you have to think right now as to how to attack it. It means that can I convert the contract into contract for surveys instead of doing this? Then what happens? A slight, what you call, relief. Under exception, I told you, if the contractor is an establishment and he has got his own setup, this one, he has issued letter of appointment and he governed by his own terms and conditions, he gives increment, he gives everything, maybe you can take that exception. These are all chances. But again, highly debatable even before a judiciary. These are all the big challenges what you are going to face.
Thank you, sir. Thank you.